You've all seen this out front. It is available for purchase and autograph by the author, so a rare opportunity. This is actually a difficult introduction for me, Jerry, but I think people could just go back to the 80th birthday celebration that we had and hear my roast of you, so I won't have to give the roast that I did. It's still on the website of the National Committee, still is regularly downloaded so they can hear my various stories about you. And
you can reduce it all to an acronym or something.
That would be a good way, but the difficulty in introducing Jerry and Maggie. Well, Maggie is easier. She's just a very accomplished lawyer who's one of, Jerry has educated so many of America's experts on Chinese law, and Maggie has followed in the footsteps.
Been one of the beneficiaries of Jerry's.
And is also a public intellectual of the National Committee, which is something that we award to some of the young China experts in the United States with the view of getting them to participate more in the public dialogue about China. And Maggie, in writing this book and working with Jerry, has done just that. In the case of introducing Jerry, I always have to say that in life there are 3 or 4 people who you always say, but for them, I would not kind of be who I am today. So, but for Jerry Cohen, I would not have had a legal education. But for Jerry Cohen, I would have never worked in the State Department. But for Jerry Cohen, I would have never practiced law on Wall Street. But for Jerry, all these other things. I could go on and take up our entire time. So he has played an incredible role in my life, as he has in the lives of many others. But today, and again, you can go and hear the roast where you hear the funnier stuff. But this is a great read. It's written not for lapsed lawyers like me or currently practicing lawyers, but for the general public to read and kind of understand what has gone on with this law in Taiwan and how it might be used as a lesson for China. But with that as the intro, let me turn it over first to Jerry to talk for 10 minutes. This is not the 50-minute law school lecture. And then to Maggie for 10 minutes. Then we'll open the floor to questions. But turn it over to you.
Thank you, Steve. We're very grateful to the National Committee for hosting us, and we hope to provide a stimulating session. There are so many people in the audience who know a great deal about the subject, whether they're from the mainland or whether they're from Taiwan. We want to make sure we have a chance to benefit from your comments and questions and maybe even criticisms. But first, since I'm an absent-minded professor, I want to thank several people who've been instrumental in helping us get this book out. Our phenomenal publisher, Berkshire Press, with 4 sturdy representatives there who have worked so hard, led by Karen Christensen and Bill Sievers, and Karen's daughter, of course, Rachel, and then Anna, I want to get her name right, Anna Myers Sabatini. They have done remarkable work. They got this book out in about 4 weeks. And we wanted to get the book out in 4 weeks because it relates to re-education through labor. And China, as many of you know, is in the midst of real ferment about re-education through labor. It has always been controversial. There was a period, 2003 to 5, when it looked like China was certainly going to abolish it or modify it. There was a bill, a draft law on the agenda of the National People's Congress. One of the leading experts in China guaranteed me in the winter of 2003 that the National People's Congress would abolish Laodong Jiaoyang this winter, and it didn't happen. And now, 10 years later, it looks like something definitely is not only going to happen, but is already happening. The only problem is we're not sure what it is. And we wanted to get this book out because it's a great story. it's potentially very instructive for reformers in the mainland because it shows not only what Taiwan has accomplished, getting rid of re-education through labor's equivalent in Taiwan, but it shows what it did along the way. And there are a number of ideas there that are potentially useful if, as is likely, the mainland will not abolish Lao Jiao. It will certainly do it in name, but I'm talking in function. And the question is, what are they going to do with it? And we can talk about that. But first, I want to say that Lao Jiao is not new in China. It was formally authorized in 1957, October. This was just the time of the anti-rightist movement, Fan You Pa Yundong. That started about June 8th, and they immediately started to use this police sanction of locking people up without asking a prosecutor, without asking a court, just the police themselves taking people in for a whole range of possible offenses, at least to them. And many of them in 1957 were political offenders. They were people who, during the 100 Flowers Bloom period, made the mistake of responding to the request for criticisms. And they made many criticisms. Many of these people were academics, some were officials, some were lawyers, and hundreds of thousands of people suffered, and some were punished criminally with severe criminal sentences, but many were given re-education through labor. Originally, re-education through labor didn't really have a time limit. It gradually underwent reform, certainly by when Deng Xiaoping took over after the good chairman's departure. By 1979, a new version of re-education through labor came out, certain improvements, but it was still a police-dominated sanction. And it's a very handy one for the police. They very badly want to hang on to this. They claim they can't be responsible for efficiently curbing crime unless they can just pick people up and themselves decide to put them away. And now, as I say, there's a lot of ferment. Now, when I first went to Taiwan, I was already interested, this was the early 60s, in re-education through labor. I was preparing a book that Harvard Press put out in 1968. It has a whole chapter about re-education through labor. And so I was curious, what did Taiwan have that might be similar? And sure enough, it did have these camps. They didn't use Lao Jiao. They used a different terminology, Guanxun, Guanli, sort of management, and Xunlian, sort of training. Sounds pretty good. Taiwan is good as the mainland in creating euphemisms for unattractive punishments. And I insisted on my host letting me go to one of these camps. First, they took me to a very beautiful new prison, and they showed me very nice prison cells, some of them inhabited by foreigners. And these were so comfortable. They had desks and chairs, a lot better than Chun Shui-bian was given when he was locked up recently. And this prison was modern. And then I said, I want to go to a Guanxun Suo, a place where they kept people on this police sanction, not a punishment that leads you to a nice prison. And I went there, and it was very, very different. It was very frightening. It was really a military camp. And the inhabitants slept in tents. There were military people around. They had very obvious weapons. And as they walked me around the camp and they shouted at these prisoners, it was like people barking at dogs. And it was a frightening amount of discipline. Well, that was Guanxun in those days. And over many years, because especially after Taiwan began to go democratic in 1987, and subsequently there was a continuing campaign to do away with what was called as the liumang tiaoli. Liumang is hard to translate, as you know. Hooligans, maybe one translation, no good nicks, petty hoods, people who had committed supposedly a variety of offenses ranging from just not obeying obvious police orders to do this or that of a minor daily basis, stop fighting, don't cheat somebody. But liumang also has been used as a cover for putting away political offenders. And in Taiwan, of course, they used it often for political offenders. Green Island was the most notorious place, but all that began to end with democratization. Well, this is a great story, and Maggie Lewis will tell you much about how it happened, and it demonstrates many things, including the role of the Constitutional Court in an increasingly democratic society. But that's why we put the book out. It's great, as the Chinese would say, 参考资料, reference material for people on the mainland. It's also great propaganda for Taiwan. One of the ironies about the Republic of China that's been on Taiwan since it was chased off the mainland in 1949 is that Chiang Kai-shek and his wife and their associates were masters of propaganda. They convinced much of America, if not all the world, that they were free China. And many people said they were neither free in Taiwan nor were they China. And now Taiwan is free, but the question still is it China? But the fact is that Jiang made it seem like Taiwan, unlike the so-called communist bandits on the mainland, was an island of freedom and rule of law. And that was nonsense. Now Taiwan has a product to sell. And the fact is, it doesn't do much to sell it. And that's what I find. They're so caught up with their own internal struggle and progress toward democracy that they haven't seen, although they need America's guarantee of their security, how important what they've accomplished for human freedom is. And this is why we took up this book. I spent about 15 or 20 years trying to persuade my students from Taiwan who went home to teach and become lawyers to tell the world in English about it. And I finally had to give up. They were too busy, so we decided to do it ourselves. We can't do it as well as people from Taiwan would do it, but we've done it. And I hope you enjoy listening to Maggie.
Thanks, Jerry. Yeah, so my interest in Taiwan started a little bit later than the 1960s, but I originally started my studies and working in mainland China, and then I had been a student of Jerry's when I was at law school, and I had had a brief stint in corporate law and went to clerk, and I had written Jerry an email while I was clerking saying I miss working on China and I'd like to get back into more of the sort of human rights issues, and Jerry, being Jerry, wrote me an email saying, "Great, come work for me, we'll find money." Okay, and I did go work for him, and he did find money, and we wrote this book. And it really started in 2005, and at that point, this act, this regulation for dealing with liumang was still very much in effect. It was being used less and less in Taiwan, but it was still a powerful tool for the police. And we made a series of several trips in 2005, 2006 over to Taiwan, working with some partners in Taiwan and law schools and also a sociologist to do not just looking at the written laws and regulations, but really trying to understand how this system operated. And that took us to meeting people at the Ministry of Justice, the National Police Agency, local police. We went and visited two of then it was turned from Guanshun to Ganshun, so the name altered slightly, but the institutes, as they were called, where these prisoners were kept, or were called, it was a 技能训练所, so a technical training institute, but the same facilities also housed most prisons. There was criminal inmates were in almost the exact same facilities, just separated by a wall. And compared to what Jerry saw when he first went, they were relatively clean, orderly, humane places, but still, there was no joke. These were people who were locked up in what was very much a prison and did not have any freedom. And so we got a sense of what was going on with the system, and from that we started looking at, well, why is this law even still in place? Taiwan has a criminal law that is fully capable of dealing with the antisocial conduct that most of what the Liumang Act covered. Taiwan also has special laws dealing with organized crime, firearm offenses, a number of the other issues that were within the Liumang Act. And it became clear that it was a law that in a lot of ways was just simmering on the books, but it had outlived its usefulness. In 2006, we worked with National Taiwan University to organize a conference that brought together a number of players in this: the courts, the police, academics, lawyers who sometimes take these cases, though most didn't have lawyers. And especially doing a lot of work in the mainland, I love going to Taiwan and having lawyers and judges and police arguing publicly, which you just don't get for the most part when you do this kind of work in the mainland, and there started to feel some more momentum to actually get rid of this law. The Constitutional Court in Taiwan, otherwise known as the Council of Grand Justices, has been around for decades, but during the martial law period, it just wasn't that active of a body. Subsequently, it's turned into, I think, a really interesting force for change in giving heft to rights in the Constitution. And the issue of the constitutionality of this Liumang Act had come before the court on a couple occasions, in 1995 and then again in 2001. And the court had taken parts of the law and found it unconstitutional. For example, it used to be that there was a secret witness system where someone who was accused of being a Liumang, who was going through this special court tribunal with very shortened, truncated procedures, would often not know who the accuser was, who the witnesses were. That was blacked out of the record, which of course made it much more difficult to mount a defense. And the Constitutional Court said this is problematic under the human rights protections in the Constitution. So fast forward to 2007, and we heard that the court was actually going to hold a hearing, which it does not always do in cases, about the constitutionality of this act. And that was prompted by two judges who actually heard these Liumang cases saying, we think there's a constitutional problem. And there's a mechanism whereby judges who have a case that they think has a constitutional issue can essentially press the pause button and then petition the Constitutional Court to address the issue. The Constitutional Court took another look at the Liumang Act, and then in 2008 issued an interpretation where it did not find the entire act unconstitutional. But what it did do was say there's a number of problems. For example, some of the categories of people who could be deemed Liumang were things like eating and drinking without paying, wandering and acting like a rascal, very broad, essentially whatever the police wanted it to be. And they said this is serious problems with the legality and actually having some notice of people of what kind of behavior would fall within the scope of this law. And at the point that the court drilled some more holes into the act but said it could still hold, most of us expected, okay, well, the legislature is going to revise the act, but it'll keep going on. And then, surprisingly, the new, at that point, Ma administration said, okay, we're going to stand behind and say, we think the legislature should actually abolish the Liumang Act, that we don't need it in Taiwan today. There's serious human rights issues with it. And then the legislature abolish the act. For someone who does legal works on human rights issues and legal reform and China and somewhat in Taiwan, we don't know how much our work contributed to the repeal, but it was certainly a wonderful triumph to feel like that this was an issue that Taiwan was taking seriously and dealt with. So at this point, it's been several years after abolition. We've received no reports that getting rid of this act has somehow created to a deterioration in public order or any problems. And as we were writing this act and this book, and our report went from current tense to past tense about what was happening in Taiwan. As Jerry explained, the debate about re-education through labor was once again simmering up in the mainland. And we are now all anxiously awaiting what the new Xi Li leadership will do about re-education through labor. Formerly, when Zhou Yongkang was the Minister of Public Security, it was very clear that the ministry did not want to let go of this power. And we have heard rumblings it will change, but will it change just in name, not in substance, is a big question. One greater issue, too, is that China has signed but not yet ratified the International Covenant on Civil and Political Rights. And that covenant requires that if you have a substantial deprivation of someone's liberty, and certainly 4 years would do it, that a court needs to be involved. And the current status of re-education through labor as entirely within the hands of the police is not the only, but certainly one barrier to China being able to ratify the ICCPR with good faith, saying that it is compliant. So I think with that, do you have anything to add, Jerry, before we toss
Jerry
the
has
questions?
a few
Yeah, I just
additional
wanted
comments.
to pick up a couple of other points. Our book is coming out next month in Chinese. It's published in Fanti Zi. It's complex characters, the traditional characters in Taiwan. We just got the jacket design today, and we also will be putting it out eventually in Gentiz, simplified characters. Chapter 1 is already in simplified characters on our U.S. Asia Law Institute website.
But we did not translate it into Chinese.
Well, I want to now come there. I see our colleague, Ms. Chun Yujie from the U.S. Asia Law Institute, and she supervised the translation into Chinese, did a lot of it herself, very close editing, and she also did critical work on research for the English volume. So we're grateful to her and her colleague, Mr. Chun Yen Jia, who's in Taiwan as we speak. Now, I sat in on a judicial hearing when they started to have the court review the decision to send the Liuman to prison. And it was, again, a very sobering, if not frightening experience, because it was like the old Star Chamber in early England. You just had a judge. There wasn't really a fair hearing. You didn't know who the accuser would be. The accuser was behind a screen. Sometimes they doctored the voice. It was weird. And I think we embarrassed the judiciary. At a conference at National Taiwan University, I asked, there were lots of judges in the audience, and I said, I've heard about this security tribunal, this special court that you have, and nobody wanted to tell me what it was like. It wasn't that it was secret, but they were embarrassed. And indeed, some of the judges were so annoyed that they had to make these decisions to send people off despite a fair trial that they asked the Constitutional Court for interpretations that proved critical. And it may be the fact that Maggie and I showed obvious interest and they knew we were going around talking helped to spur this reform, because there were many people in the Chinese judiciary and legislature and executive branch who were sensitive to foreign criticism, and they knew we were going to do something about this. At least we were going to try.
You think the fact that the president is one of your students have played a role?
Well, you know, that was my last point. Not that he was my student, but it was President Ma Ying-jeou who in January of 2009 gave the final blow to this sanction. And I'd like to think that his Harvard legal education may have had some impact on that, but I don't want to claim personal credit, because then I'd have to be taking blame for whatever torts he's committed to.
So what are the lessons then that the mainland can take from this ending of the Liuman Act in Taiwan? Because the systems are so different. You had an existing independent judiciary. You had moves towards democratization. You had the U.S. support that's so integral to kind of Taiwan's existence. So what lessons can the mainland draw from this?
Well, I think the mainland now has an increasingly educated middle class. I think they are proving restive and critical of undue government regulation. Their exposure to the legal system often makes them feel that the legal system needs improvement. The police are very unpopular in many parts of China, and part of it is they're accustomed to exercise arbitrary power. So I think the first lesson is you don't have to have political democracy to curb the police and subject them to civilized procedures. And the Chinese people increasingly are demanding civilized procedures. The second is they're demanding more and more access to courts in the hope that the courts will have a more independent, competent, honest judiciary than they've had to date. And one major lesson is China now has a constitution, and I was glad to see the communique issued by the third plenum of the Central Committee yesterday. I hope puts an end to the debate over whether China should have a constitution or should pay attention to it, because it doesn't do much in terms of our knowledge of what the economic development's next stage will be in China, but the communique does show support for constitution and independent adjudication. It's a good statement of further support for developing the legal system. And it doesn't put these two together, constitution observance and court adjudication. But I think it should, because what the mainland lacks now is a constitutional court, or it lacks an authorization to the existing courts to interpret and apply the Constitution. China is in a bizarre situation. They have a constitution. It's increasingly good in terms of calling for amendments they've had of property rights and human rights, etc. But it has no means of enforcing it. So it's konghua, empty talk, unless it's going to be enforced. The Standing Committee of the National People's Congress, of course, is authorized to apply the Constitution. It just doesn't do it. And the nearest thing to it is it has made some rulings on the Hong Kong Basic Law, and I had always hoped that it would move on from that to play a more active role. But I think China urgently needs some means of interpreting and applying the Constitution. And it may be learning from Taiwan in this respect is certainly one way to do it. And Japan has a different way of using the courts to enforce its constitution. South Korea has a constitutional court similar to Taiwan's. There are many options, and you don't have to have political Western-style democracy in order to do this. But I think a universal demand, including demands by the people in China, is that there be fundamental fairness in the way a government treats its people, and that every government should be subjected to certain limits, because otherwise we know political power runs amok and adds to dissent. So I hope the Communist Party, if only to preserve itself, will see the desirability of improving legal institutions.
And some of the lessons are very concrete. So, for example, with liumang in Taiwan, they had two categories, sort of the serious liumang, the people they were going to lock up, and other liumang they would just call warned liumang, who would basically be out on a probation-like sanction, where they'd have to check in with essentially a probation officer, the police, and have to tell about who they're hanging out with, what their job was. And one concern in the mainland is that re-education through labor is such a harsh sanction, that someone is locked up for years, and perhaps there's some way to create more sorts of probationary or other ways of monitoring people through the criminal justice system, like we use probation in the U.S., without it being such a stark deprivation of liberty. And more generally, we just are, Jerry and I and Yujia and other people who do this work with us really want to encourage a greater cross-strait dialogue about legal issues, and not just the economic legal issues, but criminal justice, human rights. For example, jury systems. Taiwan has started a pilot project where working on incorporating lay participation into criminal trials. It's not going to be, at this point, a U.S.-style jury where the power of coming back with the guilty, not guilty verdict is handed over to lay people. Instead, the idea is that some lay people will be consulting with the judges as the case goes on, but not have the final power. There's also been questions in the mainland whether, in addition to the current system of having a people's assessor who sometimes sits with the judges, though they don't seem to do much, there might be greater lay participation. Korea is having these conversations. Japan has started also using greater participation. So just that there should be more of a conversation about a number of issues involving criminal justice and human rights.
Jerry, you made reference to the communique from the third plenum of the 18th Party Congress, and it talks somewhat surprisingly about rule of law issues in a very positive way. It also announced the creation of what you call the State Security Council, what others have called the National Security Council, which is dealing with domestic security predominantly. Do you think this is an attempt, and Xi Jinping is going to head it, is this an attempt to kind of centralize the authority over these competing interests so that he can make changes, such as ending reform through labor?
Well, there was one report last week that said Xi's political power is not really complete because he wants to end re-education through labor, but hasn't been able to accomplish it. And that would be interesting. You see, we don't know whether his first year's strategy is geared to getting support for this new economic development scheme that has only been vaguely sketched at this point. We do know that it's been a very repressive year. At the same time, there's talk of economic development. They want to make sure it's under the control of the party and apparently the state-owned enterprises. And this Guojia Antren Wei and Hui, it really looks like it's trying to get control of the whole national security apparatus because there is increasing difficulty in keeping people in line, doing what the party line suggests. So you may have, on the one hand, economic development going further in a new direction. You may have an attempt to make corruption and arbitrary local exercise of police power less, but at the same time centralize power so that the localities do more what the center wants. And they're talking about, once again, it hasn't happened yet, of course, but it could happen, centralizing the power of appointing judges. Right now, judges are appointed locally. They want to centralize the power of paying courts, providing their expenses, paying judges. That would again give the center much more power. Right now, local protectionism is often the product of the fact these judges are selected, appointed, and promoted, removed locally, and they're paid locally according to local circumstances. That doesn't happen in Japan. In Japan, you have a central secretariat that keeps judges in line while still giving them judicial independence. That is quite genuine, but they know because of the circumstances that judges are not going to depart very much from the dominant values of the society. And if they do, they'll soon be assigned to Hokkaido instead of Tokyo. They have central control over these people and their careers. I'd like to see at least China get to that stage. I used to be against central control. It gave the party too much power. But in the struggle between the localities and the center, I tend to go for the center because at least they say the right things. They're putting out new laws and protections. And I think with better legal education, we might see some real improvement in the legal system.
Well, certainly we have innumerable examples of where the locality refuses to enforce rules because they, an environmental rule would be the most obvious. It's a big tax-paying entity that the central government says we've got to close down. Well, that would affect local taxes. It would affect local employment. And the pollution is not a big deal to them. So they try and close it, and the local government allows it to close for one day, and then the next day it reopens. Very
Another
common.
thing is budget. The Chinese government does not allocate sufficient budget to the central officials responsible for legal regulation. Yesterday we had a program at NYU where a colleague of mine who's a specialist in antitrust competition law emphasized that in China, when she goes there, there are only 12 or 15 specialists who work on the national antitrust law. If you go to Europe, any of these countries, they have 100, 120, 10 times more. And this has been true traditionally in China with the patent office, the trademark office, the copyright office. They're all starved for money and personnel. And it's odd, especially now when China is no longer starved for foreign exchange, to say the least.
I just want to add too that the localities have other ways too of silencing people they don't want to have out and about, and re-education through labor is I think one of the more prominent ways. But just if in case that Xi Jinping does succeed, assuming that he does want to get rid of re-education through labor, it doesn't mean that everything's hunky-dory, that there still are forced drug treatment centers, there's still a lot of extra legal ways that people might just be held under unofficial house arrest. So getting rid of re-education through labor, I think, is a major step in showing a trend in the right direction to getting rid of or at least decreasing arbitrary police power. But it's the localities, if they really have a troublemaker who they don't want to have out and about, I think they'll still find plenty of ways to do that.
But it stopped in certain places in China. Guangdong province claims that at least since March, it has not condemned anybody to re-education through labor. I was in Guizhou this summer in June, and human rights lawyers I met with said they hadn't heard, they complained of other abuses against them particularly, but they hadn't heard of anybody being condemned this year to re-education through labor. To some extent, China has a type of federal system that allows experimentation in different places and provinces, and it's plainly been happening with re-education through labor. There is no uniform regulation yet, and perhaps there will be by the beginning of next year, but this is the focal point of a great broader struggle in China over law and human rights. This is a daily struggle. Of course, we have our own daily struggles over law and human rights.
Let's go to the Bronx.
Editorial of the New York Times every day. And we have our own problems in controlling our government's actions abroad. So you can understand what's going on in China, but the thing that we have that they don't have is transparency. All of this appears in the press here, and for better or worse, and some of it may be instructive to China. But there is a fierce daily struggle going on at the leadership level. The new head of the Supreme People's Court, Zhou Chang, is an important party leader who, as Ira Belkin knows, when he was a provincial party secretary, did engage in some legal reforms. He was one of the first to study law after the Cultural Revolution restored the end of the revolution, restored admission to Beida and other places on the basis of exams. He seems like he's trying to resume the effort of an earlier head of the Supreme People's Court, Xiaoyang, who retired 5 years ago and was replaced by a party police person without similar legal instincts and training. Now, with Zhou Chang back, he's trying to provide more space for an independent judiciary to act within the guidelines of the Communist Party's leadership. But there's lots of room in the joints for what that can mean. But there are many other people who don't want to see that happen. And this struggle is going on. I wish I were a fly on the wall of a lot of these meetings.
Let me open the floor to questions. We have a very knowledgeable audience. Got Ambassador Platt.
Jerry,
We have a, don't we have a handheld mic?
Yeah, there was
how
one.
many, do you know how many people in Taiwan were held under this Liumang law?
Well, at various times, it was very significant. Some, if you go back to the 1960s,
Well,
1970s,
when we were there.
This was the Diaochaju, the investigation bureau, would just pick people up. They had terrorized people. And these were leaders of the rising DPP. It hadn't yet been called the DPP, but it was the movement for democracy that really had behind it the demand for Taiwan independence. This was very important. But of course, they didn't release statistics on it. We're only getting statistics in recent years.
And by the end, there was less than 2,000 people being held. And what's interesting, too, is that the majority, from everything we heard, of people who were being held as Liumang had parallel criminal cases because essentially the police got two bites of the apple. They could have the Liumang case proceeding parallel to the criminal case against the same person. And whichever case finished first, then the defendant, at that point turned into an inmate, would go to the punishment system for either the criminal case or the Liumang case, just depending on timing. So even when the Liumang system was abolished and these people were released, a number of them just transferred over to a prison because they had a prison sentence that they were also supposed to serve. And that means that a number weren't released into the general public. They just shifted perhaps down the street.
See, what's really at stake is, can you have a parallel system of police-administered justice that is parallel to the due process-oriented criminal formal administration of justice? The police have a choice. In China today, they can give you a little lecture, or they can give you 15 days repeatedly in a detention house under what they call the Zhi'an Guanli Trufafa, the law for the administration of, you might say, security punishments. They can give you re-education through labor to the extent they haven't stopped it. None of this goes through a court. The police often, unfortunately, also do what they feel like with no legal authority, sometimes just kidnapping and beating people, etc. Black jails, we know all that's going on. They can also use the formal criminal process. They can arrest you, hold you 30 days before they ask the prosecutor to approve your arrest. The prosecutor has 7 days, then the police can hold you for months while preparing for trial, ostensibly. Or they can give you residential surveillance. That's what Ai Weiwei got, where they give you what they like to call house arrest, but it's not your house, it's their house. And Ai Weiwei got 81 days. He could have stayed for a full 6 months the way they do it. So the police have all these options, and there's a constant struggle to reduce their options. And to the extent they can use their own administrative punishment, it undermines all the good reforms. The new criminal procedure law that went into effect January 1 has a lot of improvements in the fair administration of justice. They exclude testimony that coerce confessions that come as a result of torture. There are a lot of good things in it. But if the police don't even have to bother with the system because they can give you Lao Jiao, it undermines all the progress in the formal system. That's what Taiwan has. There is no way now in Taiwan you can be sent to detention, punished, without going through a court. And even as soon as you're arrested, they have to take you within very short order before a court. so a court can see there's a legal basis for it. And if they want to extend your time in jail, you have to have another hearing before a court. They have abolished their administrative detention law. It used to give you 30 days without even looking at you to the police. That's gone. So this is a whole struggle of who's going to control the police and what can the police do to you. This is a tremendously important. We're talking not about some banana republic. We're talking about 1.35 billion people, 22% of humanity. So this is of very profound significance.
Frank.
Frank K, USCX. I'd like to introduce a sociological element to this. Liu is, somebody like Mac the Knife in the Three Penny Opera, is a street person, is a hustler, is somebody who's on the gray end of the law. But it seems to me that if we're talking about lessons that can be learned across the straits, that's not mainly the kind of people who get caught up in re-education by labor on the mainland. It's mainly petitioners, I think. You can correct me. So it's not Liu who get caught into this and arbitrarily assigned to labor, to do labor, and by the way, to do labor for, I don't think, any salary, although
Very
products come out of it to somebody's benefit. So my wonder is, how parallel are these two situations, and how much of an example can there be when we're not talking about Liu on the mainland mainly, but rather petitioners and maybe others? You know better than I.
Well, the way that Liu was defined in the act in Taiwan was so broad. Yes, it could be your sort of almost gangster kind of bad ruffian. It could be someone running a gambling den. It could be someone who was just asking for protection money without providing the protection. But it could also, as Jerry said, especially in Taiwan's past, be used for political dissidents. And similarly, in the mainland, re-education through labor is a very flexible sanction. And
They
so
certainly use the word liumeng near too.
yeah, it's a wonderful.
Not a Taiwan term exclusively.
No, it started, of course, and historically you can see it on both sides of the strait. But it's a wonderful tool for the police to have in their toolbox because they can pull it out when maybe someone doesn't quite fit, a criminal provision. But okay, well, let's just use this because it's so flexible. So today we don't know exactly who's in re-education through labor in the mainland, but the general sense is a lot of people who are drug users, low-level drug offenses. It's used for prostitutes. Of course, it's been used for people who are adherents of the Falun Gong. But it can vary based on local conditions and the needs of the time. And so it's more that there is no exact definition of who is a liumeng or who goes through education through labor, and that's one reason the police like it so much.
UJ.
I want to follow up on the first question. By the time of 2009, when Taiwan abolished the Anti-Liumeng Act, actually only about 200 people were released from Liumeng Ganshun facilities. Others were swept into criminal justice system to deal with their illegal conduct. So the Taiwan government wasn't really reluctant to abolish the Anti-Liumeng Act because the impact to the society was relatively small compared to 20 years ago, for example. So in China, we're probably seeing similar developments. If you look at since early this year, several provinces and places have stopped approving re-education through labor cases. So if China is not going to abolish the re-education through labor system entirely, maybe reducing the number of cases of re-education through labor would be the first positive step. So what would be your recommendations for China to reduce the number of cases?
I think what they're going to do is they're going to abolish the name. They're going to send the more serious ones to the criminal justice system, either finding rubrics on the existing criminal law under which they can fit, and there are some broad provisions there, or enacting some additional provisions so that all those people will get the protections of the criminal procedures system. The others, I think, will go to drug addict trainings, prostitute re-education training. Question is, what are they going to do with the unruly people? They aren't prostitutes. They aren't liumang. They aren't druggies. These are people who aren't really committing crimes. They're exercising their constitutional right to petition, and they want to put those people away. Are they going to keep the black jails while denying them? China, by the way, was just elected a member of the UN Human Rights Council with a number of other great human rights advocates. Vietnam, Cuba, and Saudi Arabia, and a few other luminaries. But China, in the international arena, as you know, is subjected to all kinds of tests. And black jails is on the international mind now. And so I think the police, who are always looking for substitutes, they're willing to give up A if they can still use B. The police have had in the past similar things where they could lock people up, and under pressure they've had to get rid of them. But as long as they had Lao Jiao, it's been all right. But if now they have to give up their ability to just lock somebody up without question, they're going to want to find some other way to do it. Black jails are one way, but it can't last too long. Maybe they'll change the name of that too. But they are desperate to find, they used to have shelter and repatriation. It sounds so good. Shorong Chen Song. Shorong sounds more gentle than arrest and detention. We're sheltering you. We're giving you custody, treatment, etc. Well, that proved to be very unpopular with the masses of people. A lot of people died in police detention because of that. But they always need something. So this is the struggle. And by the way, the struggle includes restructuring the control of the police. That's what this national security, state security organization may be about. Mm-hmm. Is this a way to get control of the Zhengfawi, the political legal commission that was headed by Zhou Yongkang and many leaders thought was out of control? Now that he's gone, and we don't know yet what will happen to him, is this a way of getting new control over the police system? We don't know yet. So lots going on.
And as Jerry likes to say, that, like you need to have a process. We're not expecting for education through labor to just disappear, but hopefully that process will start. And also, as Jerry mentioned, the new criminal procedure law went into effect January 1st of this year. And there are some really positive things on paper. Of course, we're also waiting for some of the positive changes from the 1996 version to take effect. So, just getting it in the law does not mean it's going to happen. But when you look at, for example, the recent trial of Bo Xilai, and it wasn't open. The message was controlled, but there were these sort of live tweets coming out. We don't know what wasn't said. But it was exciting that at least Bo Xilai got to confront witnesses in court. That does not usually happen. And so it starts people thinking, so part of going to court is you get to ask questions of the person who is the witness. And so I'm not expecting massive changes overnight, but it's just starting to at least plant these seeds that might eventually grow. And you look at Taiwan, and it's massive changes in a course of less than 30 years, but you've got to be a long-term optimist to do this kind of work, I think.
Well, what was really exciting about the first trial, or first level hearing of Bo Xilai was it showed someone who exercised his right to cross-examine witnesses. And it forced the government to let some witnesses come to court. In most cases in China, witnesses do not come to court. Their testimony is read out in court by the prosecutor based on their pretrial testimony. So there's no opportunity to exercise the right to cross-examine your accusers. But Bo Xilai case, the pressure was so great they had at least 4 witnesses come to court. His wife wasn't allowed to appear, but the others were, who were key witnesses, and he, without professional finesse, but not too bad for an amateur, he did a pretty good job of cross-examining them. His problem was he had a weak case. But now, what nobody seems to pay any attention to is there was an appeal by Boishilai. The party didn't want it. I think, according to the facts, he should have been allowed a full public hearing in the appeal. But the court said that wasn't necessary. They weren't going to have another circus. And nobody's noticed. Boishilai's appeal is gone, he's gone, and they hope they'll never hear from him again. But in terms of criminal procedure, I don't think the second hearing on his appeal was appropriate in accordance with the new situation. I thought there were reasons that they should have allowed a public hearing. He had good lawyers, but the lawyers didn't have much opportunity to show their stuff. Now, maybe that's all you could hope for in a very sensitive political case. But we don't know what it means for subsequent, less political cases.
Leanne.
On a related note, Jerry, you mentioned, and in your description, in your descriptions, Maggie, I'm very excited about this topic, that transparency and dialogue seem to play an integral part in abolishing re-education through labor in Taiwan. To what extent do you feel that these elements will or may play a part in a similar movement in China?
Well, no place could be more transparent than Taiwan at the moment. You have this highly educated, fiercely competitive press, and indeed their current constitutional crisis derives from the government making public things that maybe it shouldn't have made public so quickly about investigation of crime. The mainland, of course, is certainly not transparent, although in fact public pressure is making it increasingly so, but the government is fighting a pretty successful battle, at least after a while, to keep the lid on. So there isn't the same opportunity to learn what is going on. They do have a freedom of information regulation that is sometimes used, but officials are always finding exceptions that allow them to resist the demand for information. But I think China's rule of law prospects are linked closely to China's media freedom. To the extent you can allow greater media freedom, including the internet, social media, I think to that extent you're going to get an increasingly responsive leadership in shaping a better legal system.
And not just for re-education through labor, but I think a huge force for change right now in the mainland is when individual cases of wrongful convictions or other injustice seep out. Because it used to be that if there was a case where someone was wrongfully convicted, and for example, a case where a man, Jiao Cuohai, had seen to be arguing with a fellow villager, that fellow villager subsequently disappeared. The police then found a headless body at the bottom of the well, did some police work and decided that this headless body belonged to this other villager. Jiao Cuohai confessed to killing this person. Fast forward 10 years later, thankfully Jiao Cuohai was not executed. His death sentence was commuted to a life sentence, and the dead victim returns very much alive, looking for some compensation for, I guess, some sort of social welfare he was entitled. And I mean, you don't need DNA evidence to prove the wrongful conviction when the murder victim is alive. But this story, maybe 20 years ago, 10 years ago, it could have been held down to locality. But even with the internet controls that China has in place, it's porous. And once that, you can't get that toothpaste back in the tube. Once that story's out there, people start asking questions about why did this man confess to a murder he didn't commit. Well, because it was beaten out of him. So you were seeing those kind of stories, and so not government-decided transparency, but just greater information about what's happening create really, I think, some important momentum.
I think the environment may be one lever for opening up the process. More and more people are angry and asking questions, and when they try to use the existing legal opportunities to challenge environmental situation, they're often very frustrated. So that may be one of the key ways. It isn't that people have an ideology that says, I must have freedom. But in their daily life, they encounter whether, another, of course, is people who are arbitrarily removed from their houses, forced demolition of houses, forced evacuation of where you lived for decades, farmers who have to sell their property to the government and they watch it being resold at huge prices. They want to resort to law. Chinese people want a remedy. And it isn't that they have the ideology necessarily of human rights. This goes back, by the way, to 1958, 59, the Great Leap Forward. Even ignorant farmers knew enough when all their household objects were taken away and to be melted down in the backyard so China could compete with the UK in production of steel. It was a ridiculous fiasco. They knew their property was taken away. And I remember an assistant minister of culture in 1979 having dinner with me in the Peking Hotel, telling me how he'd suffered during the Cultural Revolution. And he said to me, you don't need to have a Harvard Law School education to know when your freedom has been taken away. So I think that's what China's confronting now, not what kind of system are they going to have politically, democracy of this kind or that kind, but are they going to provide their people with opportunities to protest injustice? I think the sense of injustice is increasing in China.
I am very sorry, but it is 7 o'clock, and I need to bring the program to a close. I know we could sit here for hours and hours and hours and listen to this because it's really critical issues that are absolutely bubbling up to the surface today. But you have outside the book, Challenge to China, and the authors are available to autograph your own personal copy. But thank you so much for a fascinating program.
Thank you.